Working of patents, compulsory licenses and revocation. Chapter 16 of the Patents Act deals with working of patents, compulsory licenses and revocation. This chapter comes into effect in certain exceptional cases. Compulsory licenses are issued when there are grounds for the issuance of such compulsory licenses, and pursuant to the issuance of a compulsory license, if certain conditions are satisfied, a patent can also be revoked. The working of a patent or working of patents is a requirement that patents that have been granted should be worked. So, if you look at a spectrum of events, all patents that are granted are expected to be worked. That is at the beginning of the spectrum. If some patents are not worked, there is a possibility, given certain grounds, there is a possibility to get a compulsory license issued on those patents. So, this is in the middle of the spectrum. And if despite granting a compulsory license, if the patent is not worked or the benefit of the patent is not received by the country, then the patent can be revoked. That is at the end of the spectrum. So, working of a patent, compulsory licenses and revocation can be seen as events that would happen in sequence if certain conditions are not satisfied. So, as I mentioned, chapter 16 is a special chapter. It is triggered only in special circumstances. In India, we have had, since the 1970 Act came into force, we have only one recorded instance of a grant of a compulsory license. There have been few attempts to apply for these compulsory licenses, but there has only been one grant, and I say one recorded grant because there is some dispute that there could have been other instances. But right now we have, if we have to direct you to an order of the Patent Office granting a patent compulsory license, there is only one license available, and that is a license involving Bayer's drug Nexavar, for which Natco Pharma had filed a petition for compulsory license. So, let us look at this chapter. This chapter pertains to certain special circumstances, and the special circumstances can be triggered by certain events. One of those events is the fact that the patent is not worked in India. So, when the patent is not worked, a compulsory license becomes a way in which it can be made to work compulsorily. Now, the easiest way for us to understand a compulsory license is to look at its opposite, a voluntary license. A voluntary license is a license that is granted by the patentee to a licensee voluntarily. The terms are agreed between them, there is a contract, there is an agreement of license between them, payment of royalty, the territory, the scope, everything is decided by the license. Now, when the parties are able to come to a consensus, we call that license a voluntary license, because the parties initiate it and the parties are able to take it forward. What happens when parties are not able to come to a consensus? Company A, which is a generic company, wants to manufacture the technology covered in a patented drug, and it approaches company B, which is a originator company, the company which created the drug. Now, company B does not want to grant a license to company A. How do we resolve that situation? Now, compulsory license is one of the means by which an issue pertaining to a refusal to license can be resolved. It is one of those instances, but as I had already mentioned, there should be certain circumstances, certain grounds that are available for the licensee to make an application for a compulsory license. So, once an application for a compulsory license is made before the Patent Office, the controller will look into the merits of it and see whether the ingredients of a case is satisfied, and after hearing both the parties, he may grant a compulsory license. Now, that license that is granted is regarded as a license that is granted by the Patent Office. So, it is different from a voluntary license because the parties, at least the patentee, was not in agreement in granting that license. It went through an adjudicatory process. The patent controller decided the case after hearing the parties, and then the patent controller imposed the terms of the license. In a voluntary license, the parties decide the terms of the license, whereas in a compulsory license, the terms of a license is determined by the controller. So, with this, we start chapter 16 of the Patents Act. There are 4 kinds of applications a person can make for a compulsory license. In effect, there are 4 different types of compulsory licenses under the Act. A person can make an application for a compulsory license under section 84. This is the default compulsory license under 84. An application can be made under section 91. We will see what that is. An application can also be made under section 92. And finally, an application can be made under section 92A. These are all 4 different types of compulsory licenses. The circumstances under which these licenses are made are different. The grounds are also different. So, 84, 91, 92 and 92A are the 4 types of applications a person can make who wants to seek a compulsory license over an existing patent. Now, before we get into section 84 and see how a default, or what we call the ordinary compulsory license process, the way in which you apply and the grounds on which it is applied and how the matter is determined by the controller, before we look into that, let us look at the introductory provisions on compulsory license. Section 82 and 83 gives some introduction, or it gives some broad general principles on the working of patented inventions. Now, let us see 82 first. 82 has definitions. Usually we had mentioned this, that definitions normally figure in the definitional clause, section 2. When a definition figures in a particular chapter, then that definition will have the meaning only for that chapter, or the particular chapter, when the meaning given to that definition is confined for that chapter alone. So, 82 comes under chapter 16. So, we understand patented article and patentee for the purpose of this chapter. In fact, 82 begins, in this chapter, unless the context otherwise requires, patented article includes article made by a patented process, and patentee includes an exclusive licensee. Now, this understanding is only for this chapter.